Hi, my name is Jordan Rivera and I'm a student at Chattanooga State, and I'm going to talk about how to create a brief. If you are in the paralegal program, this is something that will be very useful for you because you cannot be a paralegal without doing briefs. Let's go ahead and start. What you do when you first start a brief is you read the case. A case will be something that the court puts together after a trial has happened, and it will tell you about what has happened in the trial, all the information that you'll need to do a brief. The first things that you need to do is determine who the parties were that were involved. That will be one person versus another person or versus the state. You need to determine what the issue is, why people went to court in the first place, what their trial was about. You need to determine the outcome of the case, what happened in the trial. Was the person sent to jail? How did the court handle the situation? Did it get appealed to a higher court and then get reversed or remanded? Meaning, did the court accept the outcome of the trial, or did they decide to change it? And that's what we mean by overturned, was the trial overturned. So sometimes someone can go to prison and then they'll appeal, and then the court may come back and say, yeah, I don't think that you should have gone to jail, so we'll go ahead and overturn the case. So when you start a brief, the first thing you're going to need to do is learn how to write the title of the case. In this particular case that I'm using, it's Bette Midler, so it's Midler v. Ford Motor Company. You need to put a period after the very end of the name of the trial and a comma, and it should all be underlined to the comma. After that, this is the book. This is what volume of a book you can find this case in, and this is the Federal Reporter 2nd edition, and this will be the page number that it's found in. The Ninth Circuit is the court that it was held in, and this is the year that the trial happened. The first thing you need to do when you're making a brief is find out what the facts were. So the facts could be 3 to 6 sentences, slightly more for some constitutional law cases and other types of law that may require more information to understand fully what's happening in the case. The most relevant facts to the case only. You don't have to put in the whole case because the whole point of a brief is for a lawyer to be able to go through and read really quickly what happened in the case so that they can determine whether in their case they can use the brief as a example of law. Courts like to take examples of law and use what other courts have already found to put it into their court. So instead of all the courts having different decisions on different facts of law, say your dog got loose and bit someone, one court found that the owner was responsible. And then if another court found, well, the owner's not responsible because who can control a dog? You want to have all the courts making the same decisions. So most cases go by stare decisis, which means if a court has already decided it, most likely a new court having the same type of case will follow the same procedure. So in your facts, you want to make sure that you are giving the most relevant information in the shortest amount of time so that a lawyer can just read through it real quickly, find out if that's really the kind of case that he needs to help his case. So this, you will describe the case and what has happened in it. In the prior proceedings, this will tell what happens in the court. So say you have a case that's been overturned. You want to know why it was overturned. So this is where you would put what has happened in the court previously to the point of law that you're trying to use at the moment. Now the issue will usually begin with whether, and it describes the issue at hand. So say your dog bit someone. Whether or not the owner is responsible for a dog biting another person. Say that other person was inside of their fence. Is that owner responsible for the dog biting? If the other person was inside of their fence, so you would use this to describe whether or not and what the issue is at hand. During the holding, this describes what the outcome of the trial was. Was it the same issue? Yes or no? Did the issue hold? So say one court decided, yes, the person is responsible. Then here you would put, yes, the court decided that if your dog is in your yard and someone walks into your yard, you are still responsible for your dog biting someone. During the rule or rationale, this is where you put what rule the court used to describe the case. So if you were to have a case and the court used a specific rule, say they used something from the Uniform Commercial Code that said that you can't marry someone if you're already married. Well, then you would state the UCC code, and then you would put states you can't get married if you're already married. And then we come down to where you put it all together. This is what a final brief will look like. Up at the very top of the brief, you would have the title, which would be the Midler v. and then the whole title would be at the very top. And I'm going to go ahead and break it down using the particular Bette Midler case. Now, in the Bette Midler case, a sound-alike to Bette Midler, someone that was sounding like Bette Midler, was used in a commercial by the Ford Company. Ford had originally contacted Midler's agent in an attempt to have Midler perform the song herself. However, her agent declined the offer. The judgment was in favor of the defendant, which means that someone came and sang one of Bette Midler's songs, attempting to sound exactly like her so that people would think that it was Bette Midler singing the song. The court found in favor of the defendant. There were no prior proceedings in this court, in this case, because the particular one I used was the very first case that they did take to court. The issue is a person's voice protected under the common law right of publicity? Can you steal someone's voice and use it in a commercial without their permission? And the holding was that Midler was not covered under the California right of publicity statute because it is limiting the use of her specific voice and not that of her intimidators. The court did agree, though, that under the common law, Ford had committed a tort against Midler. The court found that the voice of a celebrity is a personal identifier, especially for a singer who makes her living with her voice. So by using her voice, they were committing a tort or a crime against Midler. If they had just wanted to use a sound-alike and hadn't cared about using Midler, they wouldn't have asked her agent to see if she would perform the song herself. The rule or rationale that they used was the California Civic Code, and that's 3344, and the California Civic Code 990, and the common law right of publicity and the First Amendment. And that's how your brief would look. Normally when you read a brief, it wouldn't be in the block, but in order to demonstrate how you would put a brief together, this is a very simple way to make sure that you have all the information that you need in specific areas and make sure it flows in the correct order. So if you're working in a law office and your attorney asks you to write a brief for him involving a case that he may need some clarification on, may need to understand for his own case to use as a point of law, this is pretty much what you would do, to just go through and put each block of information in there, and you'll be all set to be a professional paralegal. Thank you.